Mute.
They have, you know what, they don't have that standard. Surprisingly, the goal is actually fit in there. I think so did pull the right up to get. So
How do I unmute it?
sorry. Also shout out to Jeff Zelnick, part of the see it. That's right, it's not something to maintain. Conservation standing. And that's sort of what in the southeast. Station and equipment.
Senator Mitch McConnell, the second time in 2 months, the 81-year-old Senate.
Morning, everyone.
Good morning, Judge.
Good
morning.
Your Honor.
Morning, how are you?
Good.
Mr. Jordan. What do I have today?
Mr. Jordan, Judge, and I'm the litigation manager. Good morning.
Good morning, how are you, Miss Grace?
Okay, did you see my chat?
Hold on a second. Okay. All right, everyone, we'll get started. This is our state all-purpose calendar for Thursday, August 31st, 2023. And I have the calendar before me, but we're going to start with the ACDC this morning. Are you all there?
It doesn't look like she's back.
I'm sorry.
It doesn't look like Deputy Milton is back. She said she had to go get some more inmate.
Oh, okay. Well, maybe we can take one from courtroom 2 while we're waiting on her to get it up to sign on, and then we can circle back to her, to Deputy Milton. Do we have someone in courtroom 2 who's ready?
I sure do, Your Honor. We have position number 5 and position number 6. Mr.
Okay.
Crespo.
All right.
Oh, there should be no talking. Go ahead.
Good morning.
All right, this is 23 CR 000205J, Demarcus Cresswell. I believe we have a second case ending in 5194J. In the first case from March the 7th, 2022, we have DUI, driving while license suspended or revoked, in possession of open container. And is this just a bond request on both cases? Same charges on the second case. 2 counts of DUI, possession of open container, improper erratic lane change, and driving while license suspended.
It is, Your Honor. It's a not guilty and a bond request.
All right. Do we have pretrial with his history?
Good morning, Your Honor. This defendant has 20 arrest cycles in Georgia. No felony convictions. They have misdemeanor convictions for DUI in 2018 and 2021, and 3 probation violations. Nothing further to report.
What's the convictions on misdemeanors?
They're both DUIs.
Both DUIs in 2018 and 2021.
Yes, Your Honor.
All right. State.
Your Honor, how would you like me to proceed? Do you want me to go all the way through the first case, or do you want me to do both at the same time?
We can do both at the same time. We have the March 7th of 2022, and the second case you have is August 22nd of 2023.
That's correct, Your Honor.
All right, you can go through both of them.
Okay, so I'll go through facts, and then recommendation. Your Honor, in the first matter that occurred on March 7th, 2022, an officer responded to a suspicious vehicle call. Per the caller, the car had been in front of their residence for about 20 minutes. When the officer arrived, he found the vehicle partially on the sidewalk with the lights on, the vehicle still running and in drive. Additionally, the defendant was in the driver's seat and unresponsive. The officer also noted a half-consumed 750 milliliter bottle of tequila on the passenger seat. When the officer roused the defendant, he noted the defendant smelled of alcohol, was unable to answer questions, spoke with slurred speech, slowed reactions and coordination. And the officer also recovered a 9mm pistol in the center console. Your Honor, on the later date, officers on I-20 observed a vehicle at a high rate of speed changing lanes without signaling. The defendant eventually pulled over after officers initiated their blue lights. When the officers interacted with the defendant, they noted glossy eyes, slurred speech, and the smell of alcohol. They also noted a half-empty 3.75 milliliter bottle of tequila and 3.5 grams of marijuana. Additionally, when they ran the defendant's license, they found that it was suspended for DUI and had warrants out of Henry County probation and Fulton County for an FTA, which I believe is on the first case. The reason I say that, Your Honor, I note that there's a $1,000 surety bond on an FTA. I believe that's associated with the first case. We would ask for a $2,500 surety. That'd be $2,000 on the DUI and then $250 on each subsequent charge. We'd also ask for no driving and no alcohol, drugs, or weapons. Your Honor, the reason for that bond request amount is that would match the later charge. The later case has a $2,000 surety bond on one of the DUI charges, 0 on the other DUI charge, and then $250 surety on each subsequent charge. Except I believe there's a $500 surety on the driving while license revoked. We'd ask that you maintain the bond in that case, also order no driving and no alcohol, drugs, or weapons.
All right, so in the second case, it's a 3,000 surety total.
Yes, Your Honor. And I would note for the court also that there was a 2014 DUI arrest, which I did not see any disposition for.
All right, and then on the second case, you said the second DUI count has no bond?
Yes, Your Honor. That's how my Odyssey screen read, that there was a $2,000 surety on DUI alcohol drugs and then 0 on DUI alcohol. And I presume that's because one of the charges will merge or be dropped.
Right. All right, and who's representing Mr. Cresswell?
Samantha Adams, Your Honor.
Okay, go ahead.
Morning, Judge. With regards to Mr. Cresswell, first and foremost, he is entitled to bond on misdemeanors. Secondly, Mr. Cresswell does have a pending case in Henry County. That's why he has a hold. He does want to fight his case, Judge, but it's much more difficult to do that from jail, especially too, since he has expressed to me that he is interested in DUI courts. With having multiple DUIs on his record. So he is interested in DUI court. Very hard to do that from jail, especially too when he still has to answer for the charges in Henry County. Mr. Cresswell was born right here in Atlanta, Georgia. He has 3 children. Two of them are 10 years old and one of them is 9 years old. He does have a disability and he needs to also get to the doctor so he can be seen and get the medication that he needs in order to help him through dealing with his disability. He has a 10th grade education and he's just looking to try to find ways to get his life together because he's had some challenges going on in his life. So with regards to that, Your Honor, not only does he want to plead not guilty just so he can have the opportunity to try to get his life on track, try to get into DUI court. We're also asking for that so he can go to Henry County and deal with the matter that he has pending there. And so with regards to that, Your Honor, we are requesting a signature bond on his charges. I am looking on a sheet that was printed out in the discovery that was sent over. He does have $1,000 on that failure to appear. And so we are also requesting that he receive a signature bond on there as well for that he can handle his business in Henry County.
But I thought the FTA was out of Henry. There's one out of Fulton as well, or?
I believe the FDA is actually out of Fulton, but he has a hold out of Henry.
That's correct, Your Honor. That's what my screen shows as well. The FTA out of Fulton, just a warrant out of Henry County.
Okay. My slight fear, I know that he has the hold in giving signature bonds on all these charges is definitely a problem here. And I'm not sure, don't know all the requirements for DUI court. I don't even know if he would qualify even with that.
Jack, Your Honor, I used to work in Judge Edline's courtroom, so I'm very familiar with DUI court. You have to have 2 pending DUIs within a 5-year period in order to even be considered for DUI court. Considering the fact that Mr. Cresswell does have that, he would be considered for DUI court. He would have to submit to an alcohol drug evaluation and recommended treatment. And then he would have to go through a process of being accepted into the program. It's much more difficult to do that from jail.
I do understand, but with his history, I'm just glad he hasn't killed anyone yet or had a more serious accident of that sort. And I just don't want to go down that road or think that that could be a possibility. He hasn't gotten help in all these years. I guess finally, hopefully he's ready to get some help. State, do you have anything else to say to weigh in?
Your Honor, I would just point out this defendant has, I don't have the exact count. I think it's 2 probation violation convictions, 2 additional probation violation arrests, and a recent conviction for driving without or driving while license revoked. So I don't think this defendant has shown a record of complying with court orders while out on bond.
Driving while license is suspended, correct? Not revoked.
That may be the case.
Just wanted to clarify for the court. Yeah, and that's understandable, Your Honor. However, he's trying to get his life together. He wasn't trying to get his life together before. So you know, all of these incidents have caused him to, you know, wake up in a sense.
How old is he?
He is 37 years old, yeah.
And Your Honor, I clearly don't know the requirements with the same familiarity as defense counsel, but I have a hard time understanding how the application to drug court would be more difficult from inside jail. And I presume that the state's position would change should the defendant be accepted. We'd be more amenable to recommendations then, but to let him out on bond when he has a high risk of reoffense because he might be able to get into DUI court is just not tenable for the state.
The issue is he has to have an alcohol drug evaluation and he can't do that from in here. He has to do it. It's easier to get it done from outside as opposed to waiting for somebody to come see him to complete it. And then he has to also pay for it himself. It's not possible from in here.
Well, there's a difference, counsel, between easier and not possible. Is it not possible or is it easier?
It's not possible for him to pay for it from in here because he doesn't have access to his money. His family lives here, but they are little means. If that was the case, he would have been bonded out.
So the state's contention would be that it's merely more difficult to comply.
It's not possible for him to pay for it in here, though, is what I'm announcing to the court. He would have to pay for the alcohol drug evaluation. He cannot do
Right.
that.
Well, if he has family or some persons that he could give access to his funds to be able to do that. I'm not moved at this point to give him a signature bond at all. On the first case ending in 0205J, I'm going to continue with I believe on that one is a $2,500 surety bond,
No.
2,000. Correct me,
So-
counsel.
Yes, Your Honor. On the first case, the only bond I show is currently a $1,000 surety on the FTA. State's recommendation was that you move it to a $2,500 surety to match the same surety amounts on the subsequent case.
Okay, gotcha. Okay. Sorry about that. Then I'm going to enter that $2,500 surety on the first case, the 1,000 on the FTA, but 2,000 on the DUI, 250 on the driving while license suspended, and 250 on the possession of open alcohol container for a total of 2,500. No drugs, alcohol, weapons or guns while on bond, and no driving. So if he has to go for any emergency care, I guess the ambulance could take him and that would suffice. If he has to go anywhere else, he will take an Uber, Lyft, or ride share or get a ride from someone. But I'm going to order no driving. On the second case, ending in 194J, with that one, we already have, I added up, is it a 3,000 surety?
That's
on
what I
that
have,
one?
Your Honor.
Okay, and so that first DUI on that one would be a 2,000 surety. And the DUI under the influence of alcohol would merge. But I don't know that I like saying no bond on it. Or if we're gonna go ahead and merge it, then it'll be a moot issue. And then 250 on the possession of open container, 250 on the erratic lane change, and then 500 on the driving while license suspended. Again, no drugs, no alcohol, no weapons, and no guns while on bond, and no driving for anything. Does that take care of it all, or do I need to just give another 250 on that other DUI, or is it going to merge?
Your Honor, if it would make Your Honor more comfortable, I think the state is comfortable with splitting the $2,000 surety on the first charge across both charges.
Okay.
And that way you are at least putting an amount on each charge.
Correct, because I don't, if something happens, I don't want him held because it says no bond. So let's do that. Correct that, Ms. Grace, and put the first DUI, alcohol, drugs, 1,000, and the second DUI under the influence of alcohol, 1,000. So that'll still total the same amount.
I have it. Thank you, Judge.
All right, thank you. All right, that will conclude this case.
Good morning, Your Honor. This is AC/DC.
Good
Before you
morning.
is Ms. Curry, position 7 and 8.
All right, this is position 7 and 8. What are we doing here? Let's see.
Your Honor, I've requested in the announcements that we have a social worker talk to her first. I saw in the recommendations, the state was offering part of the conditions to be meeting with PAD. So that indicates to me that probably she's already hooked up with PAD in some kind of way, probably already has a PAD person. If there's not a PAD person on the Zoom with us yet, during the court session today, I'd like to, while other pleas are being taken, I'll try to get hold of the social worker. I'll try to get hold of PAD and see if we can make sure that we have all our ducks in a row before the end of court and possibly go forward with the plea. Otherwise, I would have to reset this for a social worker visit in order to make sure that she is going to be getting treatment.
Your Honor, if I may clarify, is it defense counsel's intention to go forward with a negotiated plea on position 8, or are you doing a blind plea on position 8?
Number 8 would be a blind plea only. I don't know if I didn't look at the final type version of the announcements. I just know what I sent in. But the thing is, SDET typically costs over $1,000 to talk to a psychologist, and she has no means. So I would be proposing, if we're able to go forward on a plea today, I would propose that we just say get the treatment, which is available for free through Grady, and forget the evaluation and just go forward to the treatment and be done with it. That's what I would propose if there's a plea. But first, I have to make sure that one other person besides myself feels that competency is not an issue, because it's shaky at this point.
Your Honor, I don't want to. I don't want to disadvantage the defendant, but given AC/DC's previous announcement at the start of the calendar, it might be more appropriate for a reset.
I believe so. I'm not sure what we're doing.
Nor do I.
What are we doing, Mr. McLean?
Well, when we announce needs a social worker visit, that means we're not doing anything until the social worker talks to her and then reports to me a thumbs up or down. So it's just a check and a balance, Your Honor, to make sure the person is competent so we can go forward. I'm not at the point of saying this person definitely needs a competency evaluation, but I want a second opinion from somebody in my office who does this all the time as well.
All right, Ms. Grace, what's our reset date?
Let me double check.
Okay.
The 7th.
All right, September the 7th, we'll reset position 7.
Understood, Your Honor. And if I have communications with PAD saying that things are ready, before then, I'll ask that we try to get it in before then.
All right, and then we'll reset position 8 to September 7th as well.
That would be state's request, Your Honor, that the two cases move together.
Okay,
It does make sense they go together.
okay. All right, we will reset these for September 7th.
Thank you, Your Honor.
Thank you.
Position 10, 5 South, Mr. Evans.
Evans.
After 5 South, Your Honor, can we come back to AC/DC to do position 5 and 6 and 7 and 8 on the probation revocation calendar?
Yes, is probation here?
Yes, I'm here.
All right, thank you.
Your Honor, this is for North. I have 2 people that still need to speak to the attorneys. I don't know which one needs to speak to who.
I'm sorry, they both need to speak to me. Last night when I came to visit, the officer couldn't bring them up because they had a help call.
That's Mr. McMullen and Mr. White, correct? I mean, Mr. Dawson, correct?
No, I saw Mr. White, it was Mr. Jackson and, Mr. Jackson, and it was Mr. Dawson.
Jackson and Dawson, does anybody need to speak to McMullen?
To whom?
McMullen, Shaheed McMullen?
Shaheed McMullen.
That's you.
That's the person I'm inquiring.
Yeah.
Is he gonna be with us today?
He's on call now.
You
Okay.
gonna use my computer?
No, not just.
I don't mean to interrupt y'all. I just, while somebody's doing the case, we get this knocked out and have two birds, one stone.
Oh, no, I understand.
Your Honor, I will need to speak to Mr. McMullen either in a breakout room or on the phone. And because he was not available yesterday at all, they had moved him, and it was not apparently possible to find out the new location. So we just need to have our initial meeting with him. And that could be either by phone at the desk here or on a breakout.
I'm on 4 North. The best way to do it would be on breakout, because I don't have a cell phone.
Okay.
So how are we gonna work this out?
We'll do a breakout, Your Honor, if it's possible.
Your Honor, I'm logging back into the Zoom. He can use my computer. It'll be PD Samantha Adams' laptop.
Okay. All right, I'm gonna
Okay.
trust you all will work that out expeditiously. And which case are we starting now?
Position 10, Evans.
All right. And then I'm trying to get through ACDC after this. 23 CR 004998F. Daquan Evans charged with 1 count of battery family violence. And is this just a bond hearing or what are we doing?
Not guilty plea in a bond hearing, Your Honor.
I'm sorry.
Not guilty plea in a bond hearing, Your Honor.
All right. Pre-trial.
This defendant has 2 arrest cycles in Georgia, no felony convictions, no probation violations or FTAs.
What are the cycles?
There appears to be 2 open cases. Bear with me while I get those case numbers.
And I have those if that's easier for the court.
Go ahead.
23 CP 221013. Your Honor, that's a felony case with aggravated assault, possession of firearm during felony, and criminal trespass damage. I show that there's no bond set on that. Additionally, Your Honor, there's 23 CP 221036. That's 2 counts of theft by receiving, felony, marijuana possession, and carrying a weapon. Your Honor, that case has a $31,000 surety bond set.
All right. Go ahead, state.
Your Honor, in this matter, officers responded to a call about a female being assaulted. When they met with the victim stated that her child's father was repeatedly calling her phone, trying to see her at her home, but she told him that she wasn't at her home. The defendant then arrived to where the victim was, which was the victim's grandmother's house and the incident location, began arguing with the victim. The victim left the argument to go inside the house and end the argument, but the defendant followed her in and slapped her multiple times before fleeing. The officer did note redness to the victim's chest. We're asking that you maintain the $2,500 surety bond set. We think it's reasonable, Your Honor, and it appears that this defendant is not going to get out given his other felony cases anyway. We would ask for no further contact with the victim, Ms. Bertani Holloway, and a stay away from the incident address. And I'd like to sound from Ms. Holloway when the court pleases.
Ms. Bertani Holloway, are you on the Zoom? Ms. Holloway?
I believe it's pronounced Brittany.
I'm sorry?
I said, I believe her name is pronounced Brittany Holloway.
Oh, Brittany. Okay. All right, she's not on. Go ahead, Ms. Adams, PD Adams.
Yes, Your Honor. With regards to Mr. Evans, Judge, Mr. Evans was raised right here in Atlanta. Pretty much his whole family is here. They are of little means. He is a father of 2. very small children. One is 2 years old, one is 1 year old. In accordance with the affidavit, this incident happened in June of 2022. Since the alleged incident occurred, Mr. Evans and the complaining witness have in fact moved on. Again, they share two small children. He's gainfully employed. He's been working at a place called the Vape Shop for about a year, trying to take care of his children. He does have an open and pending felony. I believe he has court coming up. I have to double check on that. Mr. McLean has my computer, so I'm unable to double check on that. We are asking for a signature bond based on the fact that he does not have much of a criminal history, Your Honor. Although he does have these pending felonies, he would like to try to get those resolved. But as it relates to this case, Your Honor, we are requesting a signature bond.
And it may be relevant to the course of calculus. I'll just note for the open felony case with the aggravated assault charge, I only see one charge, but when I opened up the paperwork, there are 5 different victims listed. So I don't know whether or not that'll be accurate going forward, or if the charge count will change.
Based on the conversation that I had with Mr. Evans, it's quite possible that it'll change.
All right. I'm going to continue with the $2,500 surety bond. No drugs, alcohol, weapons, or guns while on bond. Stay away from the incident location and no further contact with Brittany Holloway.
Your Honor, if he does make bond, the defense would like to request at least no further violent contact. They have had no incidents since this alleged incident, and they do share a child. And so,
State's argument, Your Honor, would be that, I'm sorry.
Go ahead.
I would simply going to say state's argument would be that we haven't made contact with the victim. I don't think that's appropriate and can always be raised at a bond modification.
I agree. And due to his history and the open case, I'm not going to order any or allow any visitation with third party assistance like I do in some of the other cases, because I just don't know what the situation is. So unless he's legitimized them or has some existing parenting plan or visitation order, it'll be up to the victim. But since he can't have any contact with her, I'm not going to visit that visitation without talking to the victim or finding out what the situation is and making sure that she's going to be safe and her children will be safe without fear from this defendant.
thank you, Your Honor.
ACDC.
Position 5 and 6, Ms. Florence Gaylord.
Your Honor, if you don't mind, Mr. McLean is handling the cases that are in ACDC, so I believe he's still in the breakout space with 4 North.
Well, we can't do those. We don't have a PD. Go to different cases, sorry.
Your Honor, we're gonna go to position number 12, Mr. Marcus Goodwine on the SAP calendar.
Okay. This is 23 CR 005088E. Charged with 1 count of criminal trespass, the 2nd count of willful obstruction of a law enforcement officer. Is this still going to be a plea?
Yes, Your Honor.
Negotiated plea, I'm sorry.
Yes, Your Honor, it is.
All right, State.
Thank you, Your Honor. The state is recommending 12 months, served 28 days, credit for time served 14 days with the balance suspended, and a stay away from Georgia State University. That's all, Your Honor.
Repeat that for me one more time.
Yes, Your Honor. The state is recommending 12 months, served 28 days, credit for time served 14 days, with the balance suspended, and a stay away from Georgia State University.
Gotcha.
Thank you, Judge.
All right. PD Adams?
Your Honor, we just request that you accept the plea as negotiated.
Okay. All right, Mr. Goodwine, I understand that you wish to plead guilty today, is that correct?
Yes, Your Honor.
And you just heard the terms of the plea, is that your understanding?
Yes, Your Honor.
And I'm going to swear you in and ask you a few questions before accepting your negotiated plea. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do, Your Honor.
All right. And the first question I have for you is, are you presently under the influence of any drugs, alcohol, or anything at this time that would impair your understanding?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, I am, Your Honor.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, Your Honor.
Recording in progress.
And that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
And are you prepared and agree to waive these rights today?
Yes, Your Honor.
And has anyone promised you anything to plead guilty?
No, Your Honor.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, Your Honor.
And do you understand that if you are on probation, a guilty plea today could maybe affect that probation?
Yes, Your Honor.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Your Honor.
And so as to the charge of criminal trespass, how do you plead?
Guilty, Your Honor.
As to the charge of willful obstruction of a law enforcement officer, how do you plead?
Guilty, Your Honor.
All right, I will accept your guilty plea. And the conditions again are that you will stay away from Georgia State University. Do you understand?
Yes, Your Honor.
All right, I accept your plea.
Position number 11, Mr. Favors.
All right. This 23 CR 005086J, charge of 1 count of battery family violence. And this is a bond hearing or plea?
Not guilty, bond here.
All right. Pre-trial?
This defendant has 8 arrest cycles in Georgia, felony conviction in 2020 for aggravated assault, a 2012 misdemeanor conviction for simple battery, 2 FTAs, nothing further to report.
All right, State.
Thank you, Your Honor. This incident occurred on December 29, 2022. An officer was dispatched to 1930 North Avenue in Atlanta regarding a dispute between a female and her boyfriend. Ms. Hart advised the officer that the defendant, the father of her child, had pushed her down and slapped her in the face, which caused a cut to her upper lip and bruising to her leg. The injuries were observed by the officer and a warrant was issued for the defendant on February 15th of this year. We do understand that Ms. Hart we've gotten an update from Ms. Hart that says she would like no further violent contact with the defendant, but the state is recommending that the surety bond of $5,000 and the stay away order from Ms. Hart's residence at 2625 remain in place. We're asking for no further contact, no alcohol, drugs, or weapons, and a third-party transfer for the children. Our basis for that is that we have a 2017 ag assault and cruelty to children case. We also have a 2018 case, that's simple battery family violence with Ms. Hart, where no further violent contact was given. And we also have a 2022 case of simple battery family violence that was ultimately dismissed, but involved a member of Ms. Hart's family as well. So for the foregoing, we're asking that the bond that was set on the 19th remain in place. And I'm happy to give Your Honor the terms again of that bond if needed. And we would like to sound from Ms. Hart at the appropriate time.
All right, Ms. Hart. Is there Ms. Hart on the line?
Yes, ma'am. Hello?
Oh, yes, Ms. Hart?
Yes, ma'am. Hi.
Hi, do you, this is a bond hearing. Do you wish to address the court briefly today?
Yes, ma'am, I do.
Raise your right hand for me so I can swear you in.
Yes, ma'am.
Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, are you in fear of Mr. Favors?
No, ma'am.
Do you want to have contact with Mr. Favors?
Yes.
You have children with Mr. Favors, correct?
Yes, ma'am.
How many children and what are their ages?
We have 4, 8-year-old daughter, 7-year-old son, 6-year-old son, and almost a 2-year-old son.
All right. Were you all are married or anything?
We're in the process of getting married. We're engaged.
And so there, he's not legitimized them, nor is there any visitation schedule or order, correct?
No, ma'am, but we're gonna start the
Okay, I just want you to answer my questions, okay?
Okay.
All right. And so there was a previous case with the two of you, is that correct?
Yes.
2018?
Okay,
Okay. And so, and then there was a 2022 case dismissed against one of your family members?
Okay, 2022.
Okay, just checking with you. And so you want to have contact?
Yes, ma'am.
Okay. All right, let me hear from his attorney and then I'll make my decision.
Yes, ma'am.
All right. You can mute yourself. PD Adams?
Yes, thank you, Your Honor. I spoke with Mr. Favors in detail yesterday with regards to the relationship with himself and with Ms. Hart. They do, as stated to the court, have 4 children. Mr. Favors has worked at the Waffle House for 3 years. They are engaged. They actually were scheduled to get married within the next 2 weeks, Judge. They, at some point, were having issues in their relationship, but have since gone and received counseling for the issues that they have had in their relationship. Mr. Favors does want to fight his case and maintain his not guilty status. He was born and raised right here in Georgia. He does have a brother that lives here. And so, you know, even though he does have a past, again, because he's received some therapy with regards to that, Your Honor, he is working to move forward with his life, change his life, and have a happy life with Ms. Hart, which is why they've done the work that they've done in their relationship. Judge, we're requesting a signature bond in this case. I believe he has a pending case, and with regards to that, he's not going to be leaving the jail until after he's heard on that. And so we are requesting a signature bond or a lower bond, maybe about $1,500 on this particular charge.
All right, I'm going to order a $5,000 surety bond. In this case,
I believe there has a $5,000 surety bond on it.
I'm sorry.
But I believe his surety, but he already has a $5,000 surety on it.
Okay, well, I'm going to continue with that 5,000 surety. And I'm going to order a stay away. I think you gave me a different address state. I heard 1930 North Avenue, then I heard 2625.
Yes, Judge, 1930 North Avenue is the incident address location. It's our understanding that that's Mr. Favors' address and that Ms. Hart is located at 2625 Tolliver Drive.
Okay.
And that was my understanding of why that was the stay away address that was in the bond given on the 19th.
Okay, so I'm going to order stay away from the 2625. I'm not going to order or entertain any visitation at this time because the children are not legitimated. The parties are not married. Once that happens, and they can work that out. I'm going to order with that stay away. I'm going to order no further contact right now with the victim, Ms. Hart, Believe there still needs to be some things worked out to make sure that she and the children are going to be safe. I'm going to order no further contact. I'm going to order no drugs, no alcohol, no weapons, no guns while on bond. That should be it. All right, are we going back to
Position 5 and
ACDC?
6, yes, Your Honor, position 5 and 6, Ms. Gaylord. And then after that is position 7 and 8, Ms. Page.
All right, we're going over to the probation revocation calendar. 22 CR 001517C and 23 PV 001033 with Florence Gaillard. Disorderly conduct violation as well as probation. November 1st, 2021 and July 13th, 2023 probation.
Yes, Your Honor. Miss Graveyard, she owes probation supervision fees in a total of $120. Victim crimes fund in a total of $27. She failed to report on April 13th, 2023, May 3rd of 2023, and May 18th of 2023. And she failed to complete 8 weeks of anger management. She has 7 months and 24 days left on probation. We are recommending to continue on probation just for her to report within 48 hours upon release.
Your Honor, I did have a question about this case. I saw a notation, something about that it was done as an ordinance violation. Can anybody confirm that?
State, do we have any information on that? I see it on the calendar. State?
Mr. Walker, maybe? I'm not sure whose case this is, Your Honor. I just wanted to appear, so.
Yeah, we
Okay.
don't weigh in on probation. When you say state, good morning, are you referring to the probation office or?
Oh, no, I was just asking about the charge. The disorderly conduct is an ordinance violation.
Mr. Walker, aren't ordinance violations the maximum 120 days?
I believe it's more than 20 days. To answer your question, I do believe it's more than 20. I actually know it's more than 20 days.
Aren't they something like 120 or 180? I was thinking.
I was thinking 180.
Okay, I mean, but the calculations that the Your Honor is hearing might be affected greatly by whether if the maximum punishment is 180 or 120, either one, she wouldn't have 7 months remaining about.
And so what is your request?
Just want to find out what the calculation is of the balance remaining to see if she's got time to do everything. She's amenable, Your Honor. She's certainly willing to do what she needs to do, but we need to make sure it's a legal matter and that she actually does have a balance.
Do you have any information on that probation?
Yes, on the disposition, they put 12 months probated.
But the notation about being an ordinance violation, that's what concerned me because ordinance violations don't carry 12 months.
How are we going to work this out or get this straight, probation?
We usually just go by disposition. So if it says 12 months, that's where our calculation is coming from the 7 months, 24 days left on probation from the time it was told.
But if it's illegal or improper, need to get some advice on that.
Well, I probably have to talk to my supervisor on that one because I'm not really sure on if it's legal for it to go through as 12 months.
Well, she would like to go forward, Your Honor. She's certainly willing to do classes. If she's under legal obligation to be under probation at this time, she's certainly willing to give that her good old college try and get it done. And we are appreciative of the offer by the state to have her come out and finish up her tasks.
I guess my concern is ordering something that cannot be done or that should not be done. I'll let her stay on probation, but in your calculation, Mr. McLean, I mean, how much time does she have left?
I'm not sure. I'll tell you what, let's go ahead with the matter as proposed by the probation department. And if I find out that there is no balance, I'll make a motion in writing. Otherwise, let's just go forward with what the state is proposing today.
All right, we'll have her to continue on probation. Remember your conditions and requirements. Ms. Gail Yardell should be back here in jail. Can you do that and comply, report, follow the conditions? Okay.
Yeah, they got her on mute.
Yeah, I could read her lips a little bit. She said, okay. All right, that will conclude this case. I will not revoke her and let her remain on probation.
Thank you, Your Honor.
Mhm. Who do we have?
7 and
This is Ms.
8.
Page.
Your
All
Honor,
right. I'm sorry.
this is courtroom 4 North again.
I'm sorry.
This is 4 North again. I was
Okay.
wondering if Miss Adams is ready for a breakout.
She may be in another breakout. Where's PD Adams?
Oh, right now she's in a client interview here in this room, but certainly she could do a breakout as soon as she's through with that, I bet.
Okay, appreciate you.
Your Honor, in this particular case, I did interview Ms. Page yesterday at ACDC, and she is in agreement with this, with the probation department's recommendation of time served.
State. This is position 7 and negotiated plea.
It's
probation.
Position 7 on the
revocation.
probation calendar.
Oh, this is 7 on the probation calendar. I'm sorry.
That's correct, Your Honor.
I'm sorry, State. Go ahead, probation.
Yes, Ms. Page owes probation fees in total of $360, victim crime funds in total of $81, failed to report on November 17th, 2022, December 16th, 2022, January 17th, 2023, January 24th, 2023, and February 27th, 2023. She did not complete 1 day of anger management. Probation is asking for time served and to close case.
Probation, you're asking for what again?
Time served and close case. She has 37 days left remaining. Sorry, Your Honor.
All right, I understand it's for a criminal trespass, but I do not like hearing, I guess she really hasn't even participated at all. To close time served. I'm not excited about it, but I guess if you all have talked about it, and I'll go along with it, but it's not my desire based on her history and failure to comply or do the probation. And I know she only has 37 days left. My inclination would be to revoke her and make her serve the rest of that time. But probation is recommending to close it. Giving her a time served plea, I guess, is her lucky day.
Your Honor, if Your Honor desires, we could go into a breakout room with the court and I could give a very good reason why this is time served.
I'll move along and accept probation's recommendation. I just wanted to be a warning to Ms. Page, you may not get this grace the next time, and to learn to follow the court's orders and comply with probation. All right, we'll close our case.
Thank you, Your Honor.
Mhm.
Mr.
All right,
McLean,
we go to position number 19, Mr. Chase Pittman.
Back at 19 on the state all purpose.
That is correct, Your Honor.
Okay. This is 23 CR 005062 G. Chase Pittman charged with one count of affray or fighting.
Yes, Your Honor.
All right, and is this going to be a negotiated plea?
Yes. Yes, Your Honor, yes.
All right, state.
Thank you, Your Honor. The state's recommending 12 months to serve 30 days, credit for time served 15 days with the balance probated, a 6-week anger management course, no further contact with Mario Dawson and Brian E. Thomas, and stay away from the incident address at 160 Ponce de Leon Avenue in Atlanta, a BP gas station.
What was that second victim?
Brian E. Thomas, I have Briani. Briani, thank you.
Are those both employees at the BP?
I don't believe so, Your Honor, but if you give me a moment, I'll double check.
Seems like the defendant knew the second victim anyway. Maybe not, I was just curious. Mr. McLean, is that your understanding?
Your Honor, yes, it is our understanding. We ask the court to accept the negotiated plea of guilty.
All right. And Mr. Pittman, you wish to plead guilty today?
Your Honor.
Okay. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Your Honor.
All right, put your hand down for me. Are you presently under the influence of any medication, drugs, or alcohol?
No.
Are you satisfied with the services and representation of your attorney?
No.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
No.
And that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
No.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty? Do you understand that if you're currently on probation, your probation could be affected by a guilty plea here today? Is there a problem?
Excuse me, Judge, I'm sorry. Are you waiting on anything from the state?
I didn't hear an answer to the question, and then I thought he was speaking to his attorney.
Okay.
So again,
No, Your Honor, he's not speaking to me. Maybe just didn't pick up the answer. What was the last question, Your Honor?
okay, so my question was, do you understand that if you're currently on probation, your probation could be affected by your guilty plea here today?
Oh, yes, ma'am. I'm sorry, ma'am.
Okay, so do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, and so again, as to the charge of affray or fighting, how do you plead?
Guilty.
All right, so you have your balance is probated, and you heard the terms of that probation was a 6-week anger management course. So you'll be on probation till you complete that. You have a stay away from that BP gas station and no further contact with the 2 victims who were listed. Can you do that?
Yes, ma'am.
All right, I will accept your guilty plea. Good luck to you.
Thank you, Your Honor. Have a good day.
Thank you, Your Honor.
All right.
Position 1, Breyer.
Ms. Blunt, Ms. Adams is still talking to her client.
Okay.
All right. Your Honor, we're gonna go to position number 18, Mr. Christopher Peck.
All right. This is 23 CR 005079C, Christopher Peck. And this is a negotiated plea. Charge of 1 count of theft by taking, a 2nd count of possession and use of drug-related objects. State.
Thank you, Your Honor. The state is recommending 12 months to serve 32 days, credit for time served 16 days, with the balance probated, no further contact with Jose Solis, a theft course, and a stay away from the incident address at 1105 Holcomb Bridge Road in Roswell.
All right, Mr. McLean, is that your understanding?
Yes, Your Honor, we would ask that this go to termination or non-recording once that class is finished.
You can go to non-reporting.
Thank you.
All right, Mr. Peck, I understand that you wish to plead guilty. Is that correct? Can you hear me?
Yes, ma'am.
Okay, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you presently under the influence of any medication, drugs, or alcohol that would impair your understanding?
No.
All right, are you satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
And do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation could be affected by this guilty plea today?
Yes, ma'am.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And so, again, as to the charge of theft by taking, how do you plead?
Guilty.
As to the charge of possession of and use of drug-related objects, how do you plead?
Guilty.
All right, you will be on probation till you complete the theft class. You're to stay away from the incident location and no further contact with the victim in this case. Once you complete the theft class, you can go to non-reporting, but you will still be on probation for the 12 months. All right.
All right.
All right, good luck to you.
Position number 23, Smith.
All right, Sebastian Smith, 23 CR 005196B. Charge of one count of criminal trespass, the second count of willful obstruction of law enforcement officer. Is this still going to be a negotiated plea?
Yes, Your Honor, it is.
Okay,
Yes, Your Honor, the state's recommendation is 12 months to serve 34 days, credit for time served 17 days, balance probated with the conditions of a 6-week anger management course, restitution in the amount of $421 to the victim, Citgo gas station, and a stay away from the incident location, 3094 Washington Road.
all right. Is that your understanding, Mr. McLean?
Yes, Your Honor, and of course, I would ask the court to consider making a non-report and after he completes all conditions. Your Honor, he and I did discuss the restitution, and he understands he will pay that to the probation department. They will put it on the
All right, well, I will agree. He can go non-reporting once he's completed all conditions, which would be the 6-week anger management and the payment of the restitution. All right, Mr. Smith, are you ready to take a plea?
Yes, ma'am.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you presently under influence of any unprescribed medication, drugs, or alcohol at this time that would impair your understanding?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, Your Honor.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
And do you understand that if you're currently on probation, your probation could be affected by a guilty plea today?
Yes, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Your Honor.
To the charge of criminal trespass, how do you plead?
Guilty.
And as to the charge of willful obstruction of a law enforcement officer, how do you plead?
Guilty.
All right, so you understand your conditions, the 6-week anger management, and the restitution of $421 to be paid to the probation department.
Yes, Your Honor.
And once you complete those, I will allow you to go non-reporting, but you will still be on probation for the 12 months.
Okay, my attorney was telling me it was a place when I get released that I have to report to. Can I get like that, can I get that information? I forgot it. He had gave it to me yesterday, but I forgot it.
It's 132 Mitchell Street. As soon as you get out of the jail, go to 132 Mitchell Street, right by the courthouse.
And what was the anger management class that you had said?
They will tell you when you get to 132 Mitchell Street.
Okay.
Okay?
Yes, Your Honor.
All right, good luck to you.
Thank you.
Thank you.
Okay.
Your Honor, position number 22, Mr. Singleton.
Okay. This is case number 23 CR 005093F, Lorraine Singleton, charge of 1 count of battery. State.
1 second. What position
Okay.
is this?
22
Okay.
Singleton. Is this still a negotiated plea?
It is.
Yes, so the state's recommendation is 12 months to serve 28 days, credit for time served 14 days, balance probated with the conditions of a mental health evaluation and any necessary treatment, 6 weeks anger management, no further contact with the victim whose name is Orlando Hartwell, and a stay away from 646 Willard Avenue. And I would like to sound for the victim, Mr. Orlando Hartwell.
All right, Mr. Hartwell, are you on the Zoom call? Orlando Hartwell. Don't see him on. I see an Eric Singleton. Is that someone related?
Not sure.
Yes,
Mr.
I'm sorry.
Is that Mr. Hartwell?
Can you hear me? Yes.
Okay, Mr. Hartwell, we had a bad connection. I don't know. I can't talk to you if I can't see you, so you'd have to turn on your video.
Okay,
All right. And you're Mr. Hartwell, Orlando Hartwell?
correct. I can barely hear you, Your Honor.
Okay, I'm not for sure whose connection is good or bad. We are ready to take the plea today. Do you have anything briefly that you'd like to address to the court?
Yes, I'm Lorraine's father. I would
Hold on
love
one
for
second.
Lorraine to get a mental.
Hold on a second. We've already had that recommendation. I understand you're Lorraine's father. And so
Yes.
you've heard the state's recommendation, correct?
Yes, I have.
Okay, so they've already recommended, and that's part of the plea, is a MH evaluation.
Right.
Okay, so I don't
And
know.
just a restraining order against him coming to my home. The address is 626 Willard, not 646.
Okay, 626.
Correct.
Okay, I think they may have stated that incorrectly. Okay, we'll make that correction. That
All
will
right, thank you.
that will be in the bond conditions. Okay, I'm sorry. In the
Okay,
plea.
thank you.
All right,
I
thank you.
appreciate it. Thank you.
All right. All right, Mr. Singleton, are you ready to take your plea?
Yes, Your Honor.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, put your hand down. I'm gonna ask you a series of questions before accepting your guilty plea. The first one being, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, Your Honor.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
And you are prepared and agree to waive these rights today?
Yes, Your Honor.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
Do you understand that if you're presently on probation, your probation could be affected by a guilty plea here today?
Yes.
And excuse me, do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Your Honor.
And so as to the charge of criminal trespass, how do you plead?
Guilty.
I'm sorry. I read the wrong charge. As to the charge of battery, how do you plead?
Guilty.
All right. So I will accept your guilty plea of battery. You understand you have to have an evaluation as well as 6 weeks anger management. You are to stay away from Mr. Hartwell. Is that correct?
Yes, Your Honor.
And to stay away from the incident location, which I believe is your father's home. You to stay away from there. And if you do those things, you should be successful with the plea terms. All right.
Yes, Your Honor.
Okay.
Your Honor, could that go to non-reporting as soon as he's had that evaluation and any necessary treatment and done the 6 a.m.?
I'm not going to do that in this case, giving some of the inclinations that I'm getting here. I'm going to have him to report for the full 12 months because I don't know what that evaluation is going to tell us. So I'm not going to allow him to go non-reporting. He's got to report full time.
Your Honor, could he have a financial break on the reporting fees or a portion of the months?
I'm not able to do that today.
Understood.
Mm-hmm. All right, who do we have next, deputies?
We're going to go to position 25, Mr. Tillman, Richard Tillman. I'm sorry, Richard Tillman.
Okay.
Yeah.
This is 23 CR 00509Y. Richard Tilgham. charge of one count of criminal trespass, a second count of willful obstruction of a law enforcement officer. Is it still a negotiated plea?
It is, Your Honor.
All right, state.
Yes, Your Honor, the state's recommendation is 12 months to serve, 28 days, credit for time served of 14 days, balance suspended with the condition of a stay away from 205 12th Street Northeast.
All right. That's your understanding, Mr. McLean?
It is, and he asked the court to accept his negotiated plea.
All right, Mr. Is it Tilgham or Tilgham?
Tillman.
Tilgham. Raise your right hand for me. And I understand that you want to plead guilty. Is that correct? All right. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury? I can't hear you. Okay. All right. You can put your hand down. I'm going to ask you a series of questions. Are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding?
No, ma'am.
Okay. All right. Are you satisfied with the services and representation of your attorney? Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence? That you're giving up and waiving the right to remain silent and not testify against yourself? And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer? And you agree to waive these rights today, is that correct? And has anyone told you that you receive a lesser sentence for pleading guilty? Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation could be affected by a guilty plea today?
Yeah, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you? As to the charge of criminal trespass, how do you plead?
Guilty.
And as to the charge of willful obstruction of a law enforcement officer, how do you plead?
Guilty.
All right, so you understand that, again, you are to stay away from the incident location as part of your conditions of your plea.
Yeah, ma'am.
All right, good luck to you.
Thank you, Your Honor.
Position 1, Mr. Brian.
I still need to speak with him, but I have spoken with several others.
What's the announcement on this case?
Mr. Breyer, I have spoken with him. He is going to be a not guilty with the bond hearing. We need to have a social worker come in and see him. But it's not with regards to mental health.
Okay. So since it's a bond hearing pretrial,
This defendant is a multi-state offender with offenses out of Georgia, Texas, Pennsylvania, and New York, felony convictions in 1977 for forgery, 85 theft by shoplifting, 87 theft by shoplifting, 92 theft by shoplifting, 96 theft by shoplifting, 2021 theft by shoplifting. There are also felony convictions out of New York in 2012 for robbery, 2013 for assault, and 2019 for burglary. Nothing further to report.
all right, state.
Oh, he's on mute. You're on mute.
Gosh, that would help, wouldn't it? Your Honor, in this matter, officers responded to a theft call. The loss prevention officer at Macy's reported that the defendant entered the store around 11:45 a.m., looked for an unattended cash register, and then stole $255 out of that register. That same defendant was recorded entering into Bloomingdale's around 11 a.m. at the same location, looking for an unattended cash register and stealing $175. Both incidents were recorded on store surveillance cameras, and the criminal trespass charge is against the Bloomingdale's location. Your Honor, the state has several concerns. The first is the risk of reoffense. Often when I was looking through the cycles in New York, there would be about a 1-month time period between his release date and the new offense date. Additionally, Your Honor, this defendant has 26 cycles out of Georgia. 25 of those are previous to 1999. So the state is concerned about his ties to the community. Additionally, this defendant has an open felony case. That's tools of the crime and criminal damage in the second degree. That's a $7,500 straight bond, Your Honor. So we're asking that you maintain the bond in this case. We don't think it prejudices the defendant, and we are concerned about the flight risk and risk to reoffend. We also ask that you order a stay away from the incident location.
All right, Mr. McLean.
This one's actually.
I'm sorry, Miss PD Adams. I'm sorry.
Yes, no problem, Judge. Mr. Breyer, is residentially challenged. And so, you know, the defense is not going to deny that. However, he has been inside Fulton County for 46 days. In addition to that, he has an 11th grade education. He hasn't been able to find work, but he did have his employment is in landscaping. That's where most of his skills are. He does not receive any type of benefits, which is one of the reasons why we want our social worker to see him. He does not have a drug problem. He doesn't have any mental health issues. He is just a man who fell on hard times. Again, the state has provided that Mr. Breyer has 26 cycles in Georgia, 25 of them more than 20 years ago. And so, Your Honor, he has two cases, this one, and then I believe there's a felony pending, but the bond on this one is $5,000, Your Honor. We're requesting a signature bond or a bond for a lower amount. Probably $50, just to give some guidance to the court.
Your Honor, I'll point out, because defense highlighted it, and I'm not sure if pretrial mentioned it, there are 41 cycles out of New York. And that's largely during the time period between 1999 and now. The most recent of that is 2022. So again, concerned about ties to the community. To defense's point about the amount of time in Fulton County, this incident occurred June 29th. So it sounds about as soon as he got here.
He's been in Georgia, I believe, longer than that. He's actually born in Columbus, Georgia, born and raised. He may have traveled to New York, but he's from Georgia.
Okay, I thought you said 40 something days most recently.
He's been in Fulton County Jail for 46.
Oh, okay, I apologize.
What's the breakdown on the 5,000?
Your Honor, currently it's $2,000 surety bond on each theft by taking charge and a $1,000 surety bond on the criminal trespass charge.
All right. I'm going to continue with the $5,000 surety bond, which again, 2,000 on each of the theft cases, 1,000 on the criminal trespass. And with that $5,000 surety bond, stay away from both Macy's and Bloomingdale's. Those are the two incident locations, I believe.
Yeah, Your Honor, the state would request that you just order stay away from the location. The location would be the entirety of Lenox Square Shopping Center. I don't think that prejudices the defendant with online shopping. The location is 3393 Peachtree Road Northeast.
All right. So I will change that to stay away from the entire Lenox Shopping Center, Peachtree. He does have other alternatives to go shopping if he needs to. With that, stay away, no drugs, no alcohol, no weapons or guns while on bond. And I think that's it. Anything else, counsel?
Nothing further, Your Honor.
All right.
Y'all, position number 17, Ms. McMullen.
Okay. What's the announcement on this case?
Your Honor, we did speak in a breakout. We'd like to plead not guilty, waive the reading of the accusation during the arraignment in which we inform him of the maximum punishment and that he will have a further court notice in trial court. And we'd like to make a bond request for a signature bond.
All right, let me hear from pretrial first.
This defendant has 18 arrest cycles in Georgia, felony conviction in 2019 for terroristic threats and acts, 2 FTAs and 3 probation violations. Nothing further to report.
Okay,
Your Honor,
State,
I'm sorry. Go ahead.
Thank you, Your Honor. On August 17th, an officer responded to 3640 Kingsborough Road in reference to a dispute. Security advised the officer that the defendant had slapped a property manager who also resides in the apartment complex. The defendant advised the officer that he was in the hallway of the apartment building using a wall charger. The defendant advised he was approached by a woman, the victim, Kimberly Curtis, who asked him to leave the property. Defendant advised that he was about to leave, but she continued speaking with him. And he advised the officer that he slapped Miss Curtis in the face because she continued to bother him. The officer advised that there were recordings and he observed marks to Miss Curtis's face. We have convictions of 21 simple battery and a 19 theft by taking. And we are requesting that the bond, the $2,000 surety bond that is in place, remain in place. No further contact with Kimberly Curtis. A stay away from 3640 Kingsborough Road in Atlanta. No alcohol, drugs, or weapons. Thank you, Your Honor.
all right, Mr. McLean.
Your Honor, he is asking for the court to consider a signature bond or a very low bond such as 1,000 instead of the 2,000 in place now. Your Honor, it is mainly based on the fact that there is one count and there is one charge, and it's not a battery, it's a simple battery. So he will abide by all bond conditions. So
Okay. I'm going to order to continue the $2,000 surety bond based on his history and my concerns. And with that $2,000 surety bond, this defendant is to stay away from the Kingsborough Road address. No further contact with the victim, Curtis. No drugs, alcohol, weapons, or guns while on bond.
Your Honor, as to the arraignment, we waived the formal reading of the accusation. I believe the only other elements is just to let him know it's going to trial court and what is the maximum punishment.
All right, and with the waiving of the formal reading of the charge against you for simple battery, the maximum penalty is 12 months incarceration or 12 months in jail and a maximum fine of $1,000 that could be rendered against you if you're found guilty by the state at a trial. And you do have a right to representation into your defenses. And so you're being formally arraigned and further notice for trial as a not guilty response on your case. All right, that should conclude this matter.
Thank you.
Position number 14, Mr. Haywood.
What's the announcement on this case? 23R005066F, James Earl Haywood, 1 count of simple battery.
I'm gonna negotiate a plea, Judge.
Okay.
Are you ready for the state, Your Honor?
Yes, go ahead, state.
The state's recommending 12 months to serve 30 days. Credit for time served 15 days with the balance probated. 6 weeks anger management. No further contact with Jeffrey Miller, and a stay away from 1489 Campbellton Road, Southwest in Atlanta. Thank you, Judge.
All right. Is that your understanding, PD Adams?
Yes, it is, Your Honor.
All right. And Mr. Haywood, are you prepared and ready to take a plea right now?
Yes, ma'am.
All right, raise your right hand for me. Confirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury.
Yes, ma'am.
All right, you can put your hand down. Hold on a second. All right. Are you presently under influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
And again, has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am. I received. I recall.
Just answer the questions that she's asking you, okay?
All right. Has anyone promised you anything to plead guilty?
No, ma'am.
All right. Do you understand that if you're currently on probation, your probation could be affected by a guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am. I understand.
Okay. So as to the charge of simple battery, how do you plead?
I plead guilty.
All right. And you understand the conditions of your probation. You're to take a 6-week anger management course, no further contact with the victim, and to stay away from that Campbellton Road address.
Yes, ma'am.
All right, you can do that?
Yes, I can.
Okay. All right. Good luck to you. I accept your guilty plea.
Your Honor, next we're going to position number 26, Mr. Murphy Tyler.
I'm sorry, Judge, my computer died and I need to be let back into the Zoom.
All right, Miss Grace.
Thank you. And also too, if I can be placed into a breakout room with 4 North.
You hear that, Miss Grace?
Yes, ma'am.
Can we hold off on the breakout because the rest of the clients in courtroom 2 are Ms. Adams.
All right.
Is Ms. McLean going there or is Ms. Adams?
Right now, we go courtroom 2, we're gonna do position 26, and then everything else is gonna be Ms. Adams' case.
Yeah, thanks.
I'll hold off on the breakout.
All right. So which case are we handling?
Murphy Tyler, number 26.
All right. This is 23 CR 00508-1E. 1 count of theft by shoplifting, 1 count of criminal trespass, 1 count of willful obstruction of a law enforcement officer. State?
Yes, Your Honor. The state's recommendation is 12 months to serve, 30 days, credit for time served, 15 days, balance probated with the conditions of an anti-theft course and a stay away from the incident location, 761 Sidney Marcus Boulevard.
All right, Mr. McLean, is that your understanding?
It is, it's what we expected to hear, and he does ask the court to accept his negotiated plea of guilty.
All right. Mr. Murphy, I'm sorry, Mr. Tyler. So it's Murphy Tyler. Is that correct? Last name is Tyler?
Yes, ma'am.
All right, so I understand you wish to plead guilty today. Is that correct?
Ma'am.
All right, and I'm going to ask you a series of questions to understand whether or not you are clear about your plea that you're getting ready to enter today. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. Are you presently under the influence of any unprescribed medication, drugs, or alcohol that would impair your understanding at this time?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you're prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you you will receive a lesser sentence for pleading guilty?
Has anybody told you you will receive a different?
No, I don't think so.
And has anyone told you you receive a lesser sentence for pleading guilty?
No, no, ma'am.
And they've not promised you anything to plead guilty, is that correct?
Ma'am.
And do you understand that if you're currently on probation, your probation could be affected by a guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am, but I just have one question.
No, I'll answer any questions you have after court.
Yeah, all right. Yes, ma'am.
Okay, so as to the charge of theft by shoplifting, how do you plead?
Guilty.
And as to the charge of criminal trespass, how do you plead?
Guilty.
To the charge of willful obstruction of a law enforcement officer, how do you plead?
Guilty.
All right, and so let me ask you this. Do you understand what the conditions of your probation are?
Not fully.
Okay, so you're to complete an anti-theft class while you're on probation, and you're to stay away from that address at Sidney Marcus Boulevard.
Yes, ma'am. Okay, I understand.
Okay,
The main thing is, as soon as you're out, go straight to 132 Mitchell Street, second floor, and they'll remind you of every point.
Yes, sir.
132.
okay. All right, if there's nothing else, I will accept your plea.
Your Honor, I wonder if he could go to non-reporting status after he completes that class.
All right, I will allow him to go to non-reporting after he completes the theft class.
Thank you, Your Honor.
Mhm.
Thank you, ma'am.
All right,
Your Honor, next, can we go back to the probation calendar? This is gonna be probation 1 and 2, Mr. Christopher Bell. You go to that, you go.
all right, this is Christopher Bale, 19 CR 009299Y and 23 PV 001036. He's charged at one count of willful obstruction of a law enforcement officer and public drunk on 8/24/2018 probation.
Yes, Your Honor. Mr. Bell failed to complete a drug and alcohol evaluation. He did not appear to a court hearing on May 24th, 2023. He has 4 months and 6 days left on probation. Probation is recommended to continue on probation, just to report within 48 hours of release.
All right. PD Adams.
Yes, Your Honor. Mr. Bell, when he initially accepted his plea, he wasn't aware that he was on probation. I think there was just some sort of a misunderstanding as it relates to that. Now that he is aware, he is willing to go ahead and get that evaluation taken care of. And also to do what he needs to do in order to, complete the terms of his probation. With regards to missing court, I believe it was made in May 23rd or 25th of 2023. He just did not receive that notice. He has not moved, so it's a mystery as to why he didn't receive it. Otherwise, he would have attended court. So he does appreciate the reinstatement, Your Honor, but the only request that we have is that his probation either terminate upon completion or he go to non-report.
Okay. And that he, once he completes the, what did you ask me again? He go non-reporting upon when?
After he completes, once he has his evaluation completed, Your Honor, so long as there's no treatment required, we're asking that he either go to non-report or that his probation be terminated.
Okay. Once he has his evaluation, I'll allow him to go to non-reporting, but he would still be on probation for the 12 months. All right.
Yes, Your Honor.
And so I will not revoke him. I will allow him to remain on probation. And please comply, Mr. Bell, so that you don't come back to jail.
All right, Your Honor, next we have probation 3 and 4, Mr. Leroy Bell.
Okay. This is 23 CR 002660D. Leroy Bell. Charged with 1 count of theft by taking, 1 count of willful obstruction of law enforcement officer, and then the probation charge. Probation?
Yes, Mr. Bell owes supervision fees in total of $120. Victim crime funds in a total of $27. Did not complete anti-shoplifting course and failed to appear to a court hearing on July 11th, 2023. He has 9 months, 6 days left. Probation is recommended to continue on probation, just to report within 48 hours upon release.
All right.
Yes, Your Honor. I'm so sorry. I don't
Go
want to.
ahead.
Okay. Yes, Your Honor. Mr. Bell, the reason why I want to go backwards, he missed that court date because he moved and he did not update his address. He has since given me an updated address, which I can go ahead and place into the chat, so that he can receive any future potential court notices. The hope is he won't have any because he fully intends on complying with probation. He fell on some hard times. Mr. Bell has been diagnosed with prostate cancer, so him getting out of jail and pursuing the treatments that he needs so that he can, survive and continue to fight that horrible, horrible illness is exactly what he needs. He is very anxious to get out so that he can go ahead and get the classes done for probation. And also too, with regards to fees, he is able to pay the fees today, but he understands that he'll be able to pay them as soon as he gets out when he goes to report to probation. There was one other thing. Oh, yes, Your Honor. And we would request that he go to non-report upon completing, either terminate the probation or go to non-report upon completing the terms of his probation.
All right, I will allow him to continue on probation and be released. I will allow him to go to non-reporting once he completes the terms, but he will still be on probation for 12 months. And I think that's it. Anything else?
No, Your Honor, not for defense.
All right, thank you.
Next we have position number 2, Mr. Stephen Kavanaugh on the regular SAP calendar.
This is 23 CR 0050008E, charge of one count of battery. And it says a private attorney.
He has a private attorney in another case, Your Honor. He thought that Mrs. Feisman was gonna be representing him in this case, but he found out that he is not. With regards to Mr. Kavanaugh, this is just gonna be a not guilty plea, Your Honor, and we request that it be moved over to the division for further proceedings.
What was the last thing? I didn't quite hear you. Non-guilty and something. I didn't hear you.
Oh, that it be transferred over to the division for future proceeding.
So it's a not guilty plea. Is this a bond hearing or just an arraignment?
Just an arraignment, Your Honor.
All right, and you're waiving formal reading of the accusation?
Yes, Your Honor.
All right, Mr. Kavanaugh, this is your formal arraignment. You're being formally arraigned and you understand that you're being charged with one count of battery. And the maximum sentence for this charge is 12 months incarceration and $1,000 fine. And the state has to prove their case beyond a reasonable doubt. If they do that, then again, I've told you what the maximum requirements or maximum sentence rather for this case would be. You have the burden again to make sure your attorney is continually updated with your current address, as well as so that she will be able to get in contact with you and that you will get the notices for court. So if you move again, you have to do that. If the state gets a conviction, you could face again $1,000 fine and maximum incarceration of 12 months. I will accept your plea of not guilty. The case will be further noticed for trial by the division judge.
Thank you, Your Honor.
Position number 16, Mr. Levin.
Yeah.
That's the announcement on position 16, 230 CR, rather 005012. Mr. Loving is charged with one count of criminal trespass.
Yes, Your Honor. Mr. Loving is entering a negotiated plea.
Okay.
Thank you, Judge. The state is recommending 12 months to serve 32 days, credit for 16 days with the balance suspended, no further contact with Tara Howard, stay away from the incident address at 503 Winton Terrace Northeast in Atlanta, and at the appropriate time, we'd like to sound for Ms. Tara Howard. Thank you, Judge.
Ms. Tara Howard. Tara Howard.
Do you see her on the Zoom, Your Honor?
Yes, Your Honor.
All right. Do you wish to address the court today? This is a plea.
Yes, I would like to
Hold
say.
on a second. Hold on a second. I have to see you to be able to talk, and then I'll swear you in.
Let's see. I'll ask you to start your video. Start my video. Yes,
Hold on
Your
a
Honor.
second. I'm going to swear you in. First, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. What would you briefly like to state? This is a negotiated plea to guilty.
I'm sorry.
This is a negotiated plea that the defendant, Mr. Loving, is pleading guilty. And so what would you briefly like to state before we go forward with accepting his plea?
Yes, I would like to state Joe Loving is my son, and he does have a mental health condition that I would like to be addressed, and that I would like to have him evaluated This is a very, this is a painful situation for me. I will say for both of us, because of the property damage that was caused at the home, at my residence. Joe is, no longer able to come to the home. However, I wanted to know if someone could let me know. Joe does have, appointments and things that he needs to meet. He is currently homeless and wanting to know if there could be any type of contact as far as being able to let him know when he's able to receive his medication. He does have a mental health team. He does have an ACT team through TRAMI Behavioral Health. I'm wanting to make that known. He is being seen, and the ACT team is a team of his psychiatrist, therapist, nurse, and case manager. And just
So
wanting
if
to
he,
I'm sorry.
go ahead. I didn't want to cut you off.
Yes, just to make it known again, Joe currently does not have a place to stay, and I am working on that piece. I do not want Joe out in the streets because that will do him no good. And again, especially with his mental health condition, that will serve him no positive purpose whatsoever. He needs to continue with treatment. He needs to continue with his mental health team. I'm sorry. It's wanting the best for my son. And again, this is I apologize.
I understand it is difficult.
It's a very painful, difficult situation. And I'm just wanting, again, to make sure Joe is able to continue receiving all of his services, and to make it a point, he is homeless, and I do not want him out on the streets again, which will serve no purpose and will cause further harm to his mental health condition.
All right, thank you so much for that, Ms. Howard. Let me see, what do we have as far as the conditions for his probation? I did not hear anything about MH. It was just the no further contact and the stay away. Is that correct?
That's correct, Your Honor, but the state has no objection to adding that.
Okay, so we will add the eval, that he must have the MH eval, and to comply, Mr. Loving, with any of the recommendations for treatment and stay on any medications that you are ordered to take or recommended to take. And we're going to put that in your conditions for your probation.
Okay, Judge, this is balance suspended is what I have.
Oh, so it's not balance probated.
No,
So
ma'am.
are we changing it to that? Is that the understanding, or will the PD, Ms. Adams, agree to that?
Your Honor, if we may, our social worker, Ms. Burgess, is on. If she can have a moment to speak with them briefly, I think that may help. Additionally, I was actually going to suggest, after hearing the testimony from Ms. Howard, that he may also be a good candidate for the PAD program, but with Ms. Burgess being on, may we have a breakout with him, please?
Yes.
Mr. Jordan, can you do that?
Excuse me, Your Honor.
Uh-huh.
Yes, I have, if it's possible, you could let me know. I have a member of his ACT team, his nurse that is with us today. If she would like to, if she's able to, would she be able to add anything? Just wanting to know.
Not to what I need to do, but maybe with Ms.
Okay.
Burgess.
Yes, can she be
Um,
added to the breakout?
Yeah, they can speak in the breakout.
Yes, who needs to go in the breakout?
This Chevette, is it-
Tourist, I'm the nurse. I'm here. I'm his mental health nurse.
all right, and Ms. Burgess, does Ms. Howard need to go in?
If I could speak to his nurse, I probably can, get what I need from her.
Okay.
Okay, so just Miss Burgess and his nurse,
Yes,
just the two of you, okay.
right now.
All right, and we'll come back to this.
Okay.
So Your Honor, in the meantime, can we go to another position 3 and 4, Mr. Joshua Coleman?
All right.
Your Honor, position number 27, Mr. White.
Which one are we doing? 3 and 4 or 27?
It's 3 and 4, Your Honor.
All right, this is Joshua Coleman, 23 CR 002035C and 5010C. The first case is theft of services and possession and use of drug-related objects. The second case is theft by taking. Both of them, well, the first case from March 31st of 23, second case for August 16th of 23. What are these? It says hold for announcement.
Yes, Your Honor. Mr. Coleman is elected to enter a plea into both cases.
He would like to what?
Enter a negotiated plea on both cases.
Okay. State.
Your Honor, the plea recommendation for position 3 is 12 months to serve 30 days, credit for time served 16 days, balance probated. Anti-theft course, $25.55 restitution to the victim. I did see the note from Ms. Thomas in the chat, so I will send that victim info to her. And a stay away from the incident address, which is 3755 College Street in Atlanta. The recommendation for position 4 is largely the same: 12 months to serve 30 days, credit for time served 16 days, balance probated, anti-theft course, stay away from all Georgia Tech property.
All right, is that your understanding, PD Adams?
Yes, Your Honor. The only request I have for his two cases is that they run concurrently, Your Honor.
The state has no objection to that, Your Honor.
All right. Mr. Coleman, do you wish to plead guilty today?
You gotta say something. Yes, ma'am. Yes, Your
All
Honor.
right, I'm gonna swear you in. Raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and I'm gonna ask you a series of questions in order to make sure you understand the plea that you're entering today in both cases, okay? The first question is, are you presently under the influence of any unprescribed medication, alcohol, or drugs?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty to both of these cases, that you're waiving and giving up your right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared to agree to waive these rights today, is that correct?
Yes, ma'am.
And has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And Do you understand that if you're currently on probation, your probation could be affected by your guilty pleas here today?
Yes, ma'am.
And again, do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
So how do you plead to theft of services?
Guilty.
How do you plead to possession and use of drug-related objects?
Okay, yeah.
How do you plead to possession and use of drug-related objects?
Guilty, yeah.
And how do you plead to theft by taking?
Guilty, yes.
All right, so to both cases and all three charges, you're pleading guilty, is that correct?
Yes, ma'am.
In the first case, you have a restitution amount of $25.45 and to stay away from College Street, so you will be on probation until that restitution is paid. The second case, it will run concurrent with your probation, is again to stay away from all Georgia Tech property. You understand that?
Yes, ma'am.
Okay.
Your Honor, it's 10 cents difference, but the restitution is $25.50.
I'm sorry, $25.55. Make sure I get that correct. All right. There's nothing else. I will accept your guilty plea to both cases on all three charges. Okay.
Thank you, Your Honor.
Next, we have position 13, Mr. Greer, Carol Greer.
Judge and Mr. Pilon, who does that restitution is paid to for that first case?
I am sending an email to D. Thomas too. Do you want me to include you in on it, Ms.
Yes.
Grace?
Yes.
Okay, I'll do that. I'm sending it right now.
John, can we do position number 27? Or can we have a breakout with Ms. Adams at any point so we get these last two people?
Yeah, well, that's why I was trying to finish up in courtroom too. This is all hers, and this is the last one. She's yours after this.
Appreciate you.
Thank you, sir.
You're welcome, sir.
All right. And which one again, Deputy? I'm sorry.
It's gonna be position 13, Mr. Greer.
Okay.
Yes, Your Honor. Mr. Greer is going to be a negotiated plea.
All right.
Thank you, Your Honor. The state is recommending 12 months, serve 30 days, credit for time served 15 days with the balance suspended, stay away from the incident address 2470 Treasure Bridge Road Northeast in Atlanta. That's all, Judge.
All right. P.B. Adams, is it your understanding?
Yes, Your Honor. We just asked the court to accept the plea as negotiated.
All right. Mr. Greer, you wish to plead guilty today?
Yes, ma'am.
Raise your right hand for me. I'm gonna swear you in. Do you affirm that the testimony you're about to receive, the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and put your hand down. Are you currently under the influence of any unprescribed medication, drugs or alcohol?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That by pleading guilty, you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am. That's fine.
Has anyone told you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation could be affected by your guilty plea today?
Yes, ma'am. I do understand that.
All right. So do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And so to the charge of criminal trespass, how do you plead?
Yes.
All right. I will accept your guilty plea. You understand that you must stay away from this Cheshire Bridge Road address. Is that correct?
Fine.
All right, if you can do that, you'll stay out of jail, all right?
Yes, ma'am.
All right, good luck to you.
Y'all, you can go to 4 North.
All right, thank you.
We appreciate y'all this morning. Can we go position number 27, Mr. White?
One second.
Say that.
Yeah, give me 1 second.
All right, what's the announcement on position 27? This is 23 CR 005070J, Shawan White, 1 count of battery family violence. Is this a bond hearing or a plea?
That's gonna be a not guilty plea with the bond hearing.
All right, pretrial.
This defendant has 5 arrest cycles in Georgia, beginning in 2019, no felony convictions. Nothing further to report.
Okay,
Your Honor, to add to that, I'm showing that Shawan White also has a open battery family violence in the DA's office. That's 23 CP 221114. I'm also showing a giving a false name and loitering and prowling that is open in state court. And okay, that's all that I just wanted to add it. But in this case, law enforcement was dispatched at 6350 Oakley Road. They spoke to the victim, Ms. Kashante White. She advised to law enforcement officers that the defendant punched her in the face and grabbed her by her arm. The officer did observe scratches on the victim's arm. There currently is a $1,500 surety bond that has been set. We ask that that bond remain set in light of the other open felony case, which is the battery family violence that is still pending. Thank you.
I do have a question for the state and court. When I was looking him up in Odyssey and the paperwork that I received, it appeared, and I could just be looking at it wrong, but it appeared he had a $50,000 bond on one of these misdemeanors. And
I
so,
saw that, but when I went to Odyssey and actually looked at the order, it was a $1,500 surety. So I'm not sure why it's reflected that way, but the actual order says a $1,500 surety.
okay, that was the reason for the bond request, Your Honor, because it looked like he had a $50,000 bond, and that's very high.
right.
If the court would, well, you know, I would still request a signature bond for Mr. White. Reason being is Mr. White's gainfully employed at Amazon. He has 2 children. He has a 1-year-old and he has a newborn baby that was born since he's been in Fulton County Jail within the last 15 days. And so it is understood that he does have bonds set on his other cases. But he's born and raised right here in Georgia, so he has ties to the community. He's gainfully employed. And the alleged victim in his other case is not the same as the complaining witness in this case, Your Honor. And so we would be requesting, because the complaining witness in this case, if my memory serves me correctly, is actually his sister. And so we would be requesting a signature bond so we can try to get him out so he can go meet his baby.
And the baby is by a different person?
Yes, Your Honor.
Well, the problem is he has open cases in history that's concerning to me. To be able to give him a signature bond, I don't see it for that. I'm not sure that he understands that he can't continue to commit acts or be obviously alleged to have committed acts of battery and violence against people.
And I'm looking at the open felony case. I'm looking at the bond order. It does not list the victim's name. And the reason is that there's a juvenile victim. And, you know, I cannot say with absolute certainty that that's his child, but there is a juvenile victim in that felony battery family violence case.
So with regards to that, some way I received, information. Oh, it was when I spoke with him. I mean, he's here. We can simply just ask him whether or not his child was present during the alleged incident.
Mm-hmm.
Well, I wasn't trying to imply that the child was present, but I was saying that in his felony case that there's a juvenile victim. And that is the cause for concern, because you said he wanted to get out to see his child. I can't say that his child is the victim in the other case, but I do know that it is a juvenile in the felony case.
There's no way that that juvenile that was in that case is the child that I was referring to, because that baby was just born within the last 15 days. He has a newborn baby that he had since he's been in Fulton County custody.
Okay. All right, I'm going to still enter and enforce a $1,500 surety bond. No drugs, alcohol, weapons, or guns while on bond. And again, a stay away from the incident location or the Oakley Road address. No further contact with the victim, Ms. White. No drugs, alcohol, weapons, or guns while on bond.
Thank you, Your Honor.
Thank you.
So yeah, out of that $50,000 bond is a $1,500 bond now.
1,500, yes, surety. Good bond.
And that may need to be clarified because the order does say 1,500. However, on the jail screen, it does list
50,000.
I'm not
Okay,
sure where that came from, but when you pull up the actual order, it's 1,500.
All right, Deputy, we have that discrepancy, but it should be 1,500, 1,500.
That's on, we have two on his 3 card. One of them is EW 04100936, which has a bond of 1,500. And then we have the 23-003083. You just went from 50,000 to 1,500. That's what's on the 3 card.
What say you, Mr. Walker?
Let me take one more look at it.
Okay, hold on one second, Deputy. Let us look at something else.
One of them says issued authority from downtown. The other one says East Point, Georgia.
Right.
One second.
Uh-huh.
So when you look at the bond order, it says $1,500 surety for this case. However, when you look at the jail screen, it has this CR number and it says $50,000. I do not know where $50,000 came from, but that is incorrect and that is listed on his jail screen. So if you type in his booking number, it has his case number and it has a $50,000 bond listed. That is incorrect. And that's based off the bond order that was uploaded to Odyssey. So I'm not sure what's causing the discrepancy.
So are you saying that the only thing that should be shown on is a $1,500 one that we just handled today?
I'm saying that the state court case that has a CR number is listed as $50,000 on his booking screen, but that is incorrect. It should be a $1,500 surety bond. I see that he has 2 cases. I'm not referring to the CP case at all. I'm just strictly talking about the CR case.
I think what Mr. Walker is saying is 23 CR 005070J, which is that's also the downtown case. It is not a $50,000 bond. It's a $1,500 bond. There's a typo.
What's the gun called?
Excuse me? All right, go ahead again.
I was just trying to help Mr. Wright clarify that for the deputies, that it is a typo. It is supposed to be $1,500. I don't know who corrects that because the order says that it's $1,500. That's correct, right, Mr. Walker?
That is correct. The order is $1,500 and the booking screen is showing $50,000. I'm not sure who entered that information in, but it is incorrect. That the one that says
Yes.
downtown.
So
Right, I'm assuming the sheriff's department did that and maybe talked to your people there. Because we don't, they put the information in the booking screen and it's obvious that someone has typed it incorrect.
I'll call the jail records. He has a $50,000 bond on the CP case
Okay,
and a $1,500 bond on our case. They just mixed the two cases up.
Okay.
Oh, okay.
So he does has $51,500 bond altogether. It's just
Okay.
$1,500 on our case,
Yeah,
and he has a $50,000 bond on the CP case.
Okay.
but it still needs to be corrected though, right?
All right, I'll call jail records and
Okay.
have it up.
Thank you.
So which one I gotta take? They gotta correct this. So altogether, his total is 51.5, or is it 3,000?
Based on what Mr. Jordan just said, it's still supposed to be 51.5. It's just that the CP case is supposed to be 50,000 and the CR case is supposed to be 1,500. So there's just, the numbers are inverted. They just put them in the wrong spot.
Right.
Okay. I appreciate you. Can we go to position number 20 and 21, Mr. Sills?
May I please be placed in a breakout space?
Can we go ahead and finish up position number 16 first before you do the breakout, because I need to get him back to 3 North.
I did see a chat from Ms. Burgess asking that he be reset to the competency calendar.
Which case is that?
Position number 16, Mr. Joe Loving, Judge.
Yes, Your Honor, I spoke with his Grady Act team members, and I think that it would be better for we can work with them and get him some type of, he's already has a lot of support that's gonna help with getting him housing and stuff, and so we could place him on the competency calendar where we can work with the Grady team and making sure that he has the housing that he needs.
Okay. State, any objection to that?
No objection from the state, Your Honor. Thank you.
All right, Miss Grace, what date would he be
Nine.
on?
Is 9/14 good, Ms. Burgess?
Yes, that's good.
Okay.
All right, that's what we'll do.
So
All
then,
right, Loving, we're gonna reset you to the 9/14 calendar. And I'm assuming his mother is aware and hears that as well.
And is she on there? Or I can get the mom's number from the nurse, the case manager. I can't pronounce her last name. Where is she?
Right, okay.
I think she on here.
Chevette.
Chevette, yeah, okay, there she go. So I'll
Okay.
get the mom's information from her because I don't see the mom on here anymore.
Okay, she
I'm
may,
still here.
Oh,
I'm still
okay.
here.
Okay, can you put your information, you know how to do that in the chat or not? I can just get it from Miss Chevette.
Let me see. I think it's under more, no, chat. Let's see. I think I can. Okay, just type my phone number in here.
Yes, ma'am.
well, make sure it's coming exactly to Miss Burgess, not to the whole.
Right, you know how to do
No,
it.
I don't know how to do that.
Don't worry about it. I can get it from Miss Chevette. That's fine.
Okay,
Okay.
All right, thank you. Good luck to you, Miss Howard.
All right.
thank you.
Thank you. All right, who are we going to next, deputies?
I believe they called for Sims, Your Honor. Is he in Cornwall?
I'm sorry?
I believe they called for Sims. I'm not sure where Sims is located, but I was requesting to be placed in a breakout space with 4 North.
Okay, position 21, Kenneth Sims.
Yes, ma'am. Good morning, Your Honor.
Morning. What are we doing with this case? 20 CR 006196J.
Your Honor, he's on the revocation calendar and the SAP. On the SAP, the incident date precedes the matter for which he's on probation. It's from the fall of 2020. He's pleading not guilty, and we would like to ask the court for a bond reduction on that.
On which one? 20 on the SAP?
Yes, Your Honor.
What's the bond now?
Let's see, the bond is, if I can turn to the correct
Or I
page.
guess I could let the state tell me.
Your Honor, I have that he's being held on an FTA and probation violation bond, and that bond was set on this back in December 30th, 2020. I have a $10,000 surety on the FTA and no bond on the probation violation. The warrant on this may still reflect a $5,000 surety.
Right, it basically looked a bit complicated, but the main point was it's several $1,000s, and it would be a bit high for what we'd like to present to the court is going on. We would ask the judge to consider something in the range of $1,000 surety, $1,500 surety, even if the court cannot see its way clear to a signature bond. It does go back to 2020 in the fall.
And Your Honor, the state would just ask that the FTA be sent back to the division judge. We would like reinstatement of the bond terms that were present in December of 2020. Our reason for that is potential influence relationship to the victim and the fact that he was out on bond in this case when the 2022 case occurred last year. And when he was out on this bond, he was ordered to have no further contact with the victim, Robert Brown, who's the victim in the 2022 case as well.
Then that's all clarified. I believe he can definitely be in compliance with that notion, Your Honor.
All right.
A lot of water has gone under the bridge, let's put it that way, and there's clarity on staying away, and we don't want to imply or have anyone infer that there's any influence at all. There's not.
It's just the state's concern, Your Honor. This victim has been a victim of the defendant twice, so we just wanted to note that and request that the FTA go back to the division judge. Thank you.
All right, so again, making sure I understand what we're doing today on position 20 on the SAP calendar. That is a $10,000 surety bond.
No, we believe it's just on the FTA itself.
I thought on the FTA there was no bond.
There's no bond on the probation violation, Your Honor, which is I have that as a separate case.
All right.
So Your Honor has the FTA as listed on the SAP calendar. For the probation violation, I have 23 PV 001031 based off an April 2023 arrest warrant, according to Odyssey, and then I believe arrested August 11th.
Okay. I don't see all of that, don't have all of that. So I just want to know what we're handling and what I need to do because I'm a little confused right now. So let me start with the SAP calendar, position 20, 20 CR 006196J. What are we doing on that case?
Yes,
that's an arraignment.
I'm sorry, 2020.
20 CR 006196J.
Okay, that one's an arraignment?
Yes, he's pleading not guilty, and we're going to waive the formal reading of the accusation and the bond. The bond on that is not something we need to deal with at this time. Is that correct?
Okay, so let me start there. And with this case, Mr. Sims, 20 CR 006196J. You're charged with one count of battery, substantial physical harm. Your attorney has waived the formal reading of the accusation. That offense date is November the 18th, 2020. And I want you to know again that you are being charged with this battery, substantial physical harm, which has been formally accused by the Solicitor General's office. It carries a maximum sentence of $1,000 for the fine, and 12 months in jail is the maximum for this case. Again, it will be reset for a jury trial. That trial will be scheduled by the division judge, which is where the case is going to be sent back to for further notice. Again, at that jury trial, you will have a right to an attorney. You do not have the burden to prove the charges at trial. The Solicitor General's office will bear the burden to prove that beyond a reasonable doubt. And again, if they get a conviction, I've just told you that the maximum is $1,000 fine, 12 months in jail. So again, based on this information, do you plead not guilty to this charge?
Where did
Where you go?
go?
Or North, I lost you.
Yes, ma'am. Can
Lost
you hear
the
me, Lord?
video. I'm sorry.
Can you hear me?
I can hear you. There you go. All right. So again, as to this charge of battery, substantial physical harm, do you plead not guilty?
Yes, ma'am. I do.
All right. I will accept your not guilty plea. So you've been formally arraigned on that case. And then the FTA on the same.
Right, Your Honor, we are pleading not guilty as the FTA. It was inadvertent and not intentional. And Your Honor, the problematic part is the $10,000 bond on that. We understand the state wishes to send it back to the trial judge. That's certainly appropriate. But that $10,000 bond is a problem at this time because I'm about to address the probation revocation matter. If that could be something like 2,000 or 1,500 or 1,000, that would be great.
Well, I've not heard any information regarding his history. So I would need to hear that from the state or from pretrial.
Understood.
Hey, Your Honor, this defendant has 6 arrest cycles out of Georgia and South Carolina, no felony convictions, 1 FTA and 1 probation violation, and it's the ones that are on the calendar. Nothing further to report.
All right, thank you. Do you have anything else, ASG Ferguson?
Yes, Your Honor, the state would just remind the court about the 22 CR case that did occur after this case, but it is the same victim. Thank you.
All right. And so there's a $5,000 surety bond on this FTA, correct?
The booking screen is showing 10,000.
Oh, 10,000 ASG Ferguson.
On the FTA, it's showing 5,000 on the battery.
One person says 5, one says 10.
No, the original bond was $5,000, Your Honor, but then he FTA for a jury trial calendar on June 5th in front of Judge Besson. So when she issued the bench warrant, she doubled it. So he has already made bond on the 5,000, but because he FTA, the bench warrant was issued, and the bond amount for the FTA is now $10,000. So typically what we do is we send it back to the division judge so they can make a final determination on the bond or the FTA, since Judge Besson was the one to issue that warrant.
Right. Yeah, I'm not going to change anything. I'm not going to reduce anything. The 10,000 will remain and be sent to Besson. I just want to be clear on the amount. I don't like to kind of state the wrong amounts because then that kind of sets in people's heads and then they'll say, oh, Judge Mincy got it wrong. But I want to stick to what the record shows. So
Understood. My apologies, Your Honor.
That's okay. We'll leave it at the 10, which is what Judge Besson said, and send it back to her for further resolution. Okay. And so then the 2 on the probation revocation calendar, what are we doing with those?
Yeah.
Go ahead. I'm sorry.
Yes, Your Honor. So he didn't complete the domestic violence intervention program, 60 hours community service, and he didn't appear for a hearing on April 12, 2023. I believe he has 2 months and 3 days remaining left on probation. Probation is recommended to revoke the remaining balance.
All right, Mr. McLean.
Yes, he's thrown himself on the mercy of the court on the probation matter, the certain number of days that are remaining. He would like to ask the court to simply cut that. I'm in possession of an incident report in which he was attacked in the jail. He's not a large person. He's beaten up in the jail. The initial report had to do with the other person was claiming he was the victim, and the deputies investigated and found out that clearly he was the victim and the other person was the only person charged. With concerns for his safety, Your Honor, I understand that the 10,000 on the matter we just handled a moment ago is going to be a problem in his being released from jail because he doesn't have the money to make the $10,000 bond. However, on this matter, if the court can see its way clear to making, instead of that many days of revocation, if the court could simply revoke him for only, say, 20 days or 15 days or 25 days, we're just trying to get a little bit of daylight, a little closer to freedom so that he can address the 2020 matter. And he is remorseful and apologetic about not having been able to complete his probation conditions.
And so the recommendation by probation is to continue.
No, they were.
Our recommendation was to revoke.
Oh, okay. And to serve the balance of how much?
2 months and 3 days, so it's 80 days.
And simply, Your Honor, what I'm putting into the mix there is a sympathy factor in a sense that might be maybe I could put that differently, but he is being attacked in the jail. He's not a large person.
Well, he's still not going anywhere because of the bonds, correct?
I will communicate with whoever is the public defender in the trial division and say, hey, how fast can you get it on a calendar?
Mm-hmm. But the probation revocation is based on, and let me, Officer Allison, based on him not doing what again?
He not doing the domestic violence program, 60 hours community service, and he also missed a hearing on April 12th.
Do you have any response to that, Mr. McLean?
Your Honor, he regrets that. He has his hand up to speak and he's on mute. We generally ask our clients to let us do the talking once we've gotten their points. I would ask him to consider that, but if he insists on speaking, I have to respect that too. But I would ask him to let Your Honor make a decision on what's before the court now.
I will, and I'm making sure I didn't have a long criminal history, but I had Georgia and South Carolina with no felonies. I will not revoke him and allow him to stay on probation with the case.
Thank you.
All right.
Your Honor, if I could weigh in, the only issue with that is he was required to do FFIP. As you know, FFIP is a 24-week program, and he only has 60 days, I believe. So
I thought it was 80, no?
It's 80 days.
I'm sorry, 80 days.
2 months, yeah. But it's not
Nonetheless, he only
enough
has 2
time.
months left. FFIP is 6 months. It's a 6 months program. So
Well, he's not going to be free yet until the other matter goes to the other court. But if he gets free, it would be appropriate to modify that to some anger management classes that could be done because FFIP never gets cut short. We understand that.
I guess you would have to take it up at that time. I don't know that I would not modify it at this time.
Right.
Um,
Sometimes we just observe and note the impossibility of a task being done in the future.
yeah, I know the state would probably object to that. So,
I had noted, you know, the 2020 matter was not charged with battered family violence, and I was inferring from that they were apparently not under the same roof prior to a different date later.
right, that one was just a battery substantial physical harm.
Right, there were marks alleged.
That's correct, Your Honor. The officer went to the hospital to interview Mr. Brown for that case, where he observed that Mr. Brown's eye, the victim in this case, had been closed shut, and his allegation was that the defendant had punched him with a closed fist. But it was not charged as family violence. He indicated that Mr. Brown was his ex-boyfriend, and he either had at the time or previously had a TPO, but it was not family violence, just battery substantial.
All right, what would be the recommendation on how to resolve this probation revocation? Since we only have 80 days.
I would concur with Officer Allison that the balance should be revoked.
Because he won't be able to complete the FVIB
That
anyway.
is correct, and it sounds like he had a hearing scheduled because he was not attending the courses. He did not do the community service. It sounds like he had a hearing back in April. He was at FTA on that, and now he's here on this matter because he was finally picked up. So it's clear that he's not compliant. He did not show up for his hearing. He has not done any of the conditions. As I stated, FVIP has a 24-week program. He has approximately about 8 weeks left. Essentially, it sounds like he's done nothing for about 10 months on probation.
Yeah.
Nor did he show up. So, I mean, it would be my recommendation that his balance is revoked.
All right. Yeah, I do, now that I'm clear and have the additional information. Mr. Sims, I don't know, Mr. McLean, if you want him to speak briefly. He is trying to do that. I don't know if it's going to be in your best interest to speak.
Right, Your Honor. My main point would be it would help an overall situation. He is getting attacked in the jail, my folks. So we've asked to get a chance to get out a little earlier. There would be he's going to defend himself vigorously in the 2020 matter, and those are he's presumed innocent until proven guilty on that case. Those are just different facts back from 2020, which is basically a couple months. That's going on 3 years.
Your Honor, I did do my community service. I did 30 hours of it with Hands of Hope. I also was conversing with my probation officer, letting her know that at the time of me being on probation, I wasn't working, and that the classes were very, very expensive. And in fact, for me to go to court, we're going to go to court so we can see if we can get me in some different classes or some anger management classes, because I was compliant all the way up to April when I missed that court date. And the only reason why I missed that court date was because I was evicted from being from the previous charge. But I have every intention of doing whatever the terms were from my probation. I did do 32 hours of community service, and I also was in communication with my probation officer about the discrepancies with me being able to afford the classes. They were very, very expensive, and I could not afford them. So I let her know that. I just missed the court date because I didn't have any mail coming from going to my grandmother's house from my old apartment. So that's the only reason why I got the FTA. Well, the probation violation was because I didn't go to the court hearing to get the classes reduced or to see what they were going to do with the classes. But I did find the class, and my grandmother said that she would help me. So the classes will be done if you wanted to extend my probation or if you wanted to do whatever. I don't have any problem with doing that now, and I'm able to do it now.
I don't think a probation could be extended. It's just that if he had, and I understand his intentions, had he gotten clarification on it, he would have been you would have been informed that you can't, with the BFB plea, you can't delete, you can't change it over
If
unless
you would have wanted me to go to the classes, I will be able to do it.
circumstances then. But his grandmother, I'm sure, would have helped him with the financing of it. Sounds like he was just in really bad financial shape for a while there.
Yes.
Right, but even so, you still have the duty, as you say, to report to that or let your probation officer know.
I
So
did.
that they would not have to, well, if they knew, they wouldn't have filed to revoke you. But I guess
No.
you were revoked too because you didn't show up in court. So that's
No.
very important, and that's what I base my decision on.
No, ma'am. I conversed with her and I told her that I couldn't afford the classes, and she said that she was gonna have to send me back to court to see what they wanted to do about the classes. But I was in communication with her the whole time about me not being able to afford the classes.
Well, if you were, you would have known about the court date and showed up. You missed the court date for that.
Okay, yes, ma'am. Yes, Your
Okay,
Honor.
so that's where I'm going to. You were given that opportunity and you missed that. So that's why they're revoking you. So if you were in close communication and contact, she would have also, your probation officer would also told you about that April date. And then you would have been there to get what you needed, but you missed all of that.
Absolutely. That's correct, Your Honor.
Okay. So I have to look at the facts as they are and as they come down to me. And I understand you're pleading your case. But I'm going to have to revoke you because I don't have anything else to do or that I could do, because I cannot change the conditions at this point, and I cannot do that. The opportunity for that has passed. So unfortunately, I'm going to have to revoke him.
What does that mean?
We're just asking the court consider revoking, not the whole time to stay half of it.
And what says the state?
It's my opinion that the entire balance should be revoked. And from my understanding, they already get 2-for-1 credits. So in essence, you would only be revoking half of the balance.
Right, anyway.
So I guess they want you to revoke a quarter of the balance, because if you do another half, that would be a quarter of what's left. He's already more than likely going to get 2-for-1. So
right. Yeah. I will revoke the whole thing with the 2-for-1. It's still going to be 40 days anyway. So I agree with the state's position on that. So the 2-for-1 is just going to be 40 days anyway. So I will have to revoke him. I don't have any other options at this point because of the time frame. And we can go from there with the division judge after that.
Right, in the revocation, if it could be parenthetically noted that we would expect the 2-for-1, that would be super. Thank you.
All right. I can put that in there that we will assume that that's what's going to be done, is a 2-for-1 in the revocation.
Thank you, Your Honor.
All right, thank you.
I don't know what none of this means.
Your Honor, is that 40 more days or that 40 days from the time he was incarcerated?
I'm sorry?
Is that 40 more days or 40 days from the time he was incarcerated?
Mr. Walker or Mr. McLean,
Let's see, the date of incarceration, let's see,
because I don't have that on my calendar.
August 11th.
If I might.
was the deputy asking how many days were left, or?
Well, or when it starts from, and I don't know what his date of arrest was. I don't have that information.
I'm flipping to the booking sheet. I think that was
August 11th.
August 11th is correct. Should be on this sheet. August 11th, Your Honor. That is correct.
So deputy, that was your question?
That was a defendant's question, Your Honor.
Oh, defendant's question.
Yes, ma'am.
He can talk to his attorney about that.
If that could start on August 11th, that would be great, but yeah.
All right, thank you.
Can we get a breakout for Can we get a breakout for positions 9 and 15, please?
Your Honor, can probation be excused?
Oh, yes, that's it for you today. All right, thank you.
Thank you. Have a good one.
You too.
Judge,
Yes.
since we're holding on just 3 cases, seems like one of them is a plea. Can we start resorting to SAP calendar?
That will be fine.
And that way we're just going to the competency once these 3 are done.
Right. Okay, that's fine.
Thank you. I'm about to start. I don't know who wants to listen in. Position number 1, reset jail jury. Position number 2, reset jail jury. Position number 3 and 4 were pleas. Position number 5 and 6, reset jail jury. Position 7 and 8, reset 9-7 SAP. Position number 9, we are holding. Position number 10, reset jail jury. Position number 11, reset jail jury. Position number 12 was a plea. Position 13, 14, and 13, 14 were pleas. We are holding on 15. Position 16, reset to the 9-14 competency calendar. Position 17 was reset jail jury. Position 18 and 19 were pleas. Position 20, reset jail jury, along with position 21. Position 22 and 23 were pleas. We're holding on position 24. Position 25, 26 were pleas. Position 27 was reset jail jury.
Okay.
Right, that's before this time.
Pardon me, Your Honor. I have an announcement.
Hello, I'm
Yes.
sorry.
Okay, with regards to position number 15, Mr. Jonathan Jackson, that's going to be a negotiated plea. But in speaking with Mr. Mario Dawson, he is position number 9. He needs a conflict attorney. If we could get maybe Ms. McLeod or someone on the line to talk to him, I'm pretty sure his case will probably be able to be resolved today. It's just that we represented one of the other people involved in the case, so he needs a conflict attorney.
I don't know how to do that at noon. That's gonna be on you all.
Okay,
Wish we would known that earlier.
Yeah, I wish I had known that earlier as well, but what I can do is reach out to Ms. McLeod right now while we're taking the plea from Mr. Jackson.
Okay,
Thank you.
all right, Mr. Jackson. Is this Mr. Jackson in Fort North?
Yes, ma'am.
All right. I understand that you want to enter a plea today in 23 CR 001272G to charge a simple battery, family violence, criminal trespass, the offense date being 9/2/2022. Is that correct?
Yes, ma'am.
All right, state.
Thank you, Your Honor. The state is recommending 12 months, serve 360 days, credit for time served 180 days with the balance suspended. Thank you, Judge.
All right, and balance suspended, okay. All right, is that your understanding, Mr. McLean or PD Adams? Who's he represented by?
Oh, we both have spoken to him, and yes, it's both of our understanding, Your Honor.
All right, Mr. Jackson, I'm going to swear you in and make sure that your plea is free and voluntary, that you understand what you're doing today, okay? Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury? You're on mute.
Yes, ma'am.
All right, put your hand down. And let me ask you this, the first question being, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty today, you are giving up or waiving your right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you're prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
Are you, oh, I'm sorry, has anyone promised you anything to plead guilty today?
No, ma'am.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be affected by your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
As to the charge of simple battery, family violence, how do you plead?
Plead guilty.
And as to the charge of criminal trespass, how do you plead?
Plead guilty.
All right, and I understand that this is 12 months probation, credit for time served at 180 days, and the balance is suspended. All right, so that is it. You don't have any other things or conditions to do regarding this charge, this case. So I will accept your guilty plea.
All right, thank you, Your Honor.
All right, you're welcome.
Your Honor, I know that the court is getting ready to go into the competency calendar. But if I'm able to get Ms. McLeod on, she just be placed into a breakout space with 4 North so she can speak with Mr. Dawson if I am able to get her here. Judge Mincy, I'm not sure if you heard me.
Say that again?
Yeah, I wasn't sure if you heard me. I'm still working on trying to get Ms. McLeod on. If I am able to get her on while you are in the breakout space for the competency calendar, I just wanted to ask if it would be okay if she can be placed into a breakout space, or go ahead and call 4 North so she can speak with Mr. Dawson and his case be handled at the end of that calendar.
All right, I will do that.
Okay, thank you.
Your Honor, I'm a little ignorant of how this process works on the other end, so I don't know if this will affect your calculus, but I'll let you know this defendant is in on a felony case and just had his 2,000 surety bond in that case surrendered. So I don't know if he's going to be prejudiced by extending.
He may be.
Okay.
That's a good point. We'll see what his attorneys are trying to do.
Judge, also, we're still holding on 24.
Yeah, I thought we had some other cases. That wasn't it. Trenton Thompson. And there's someone who is in the chat. It was earlier, but I don't even see that case. Well, maybe that's on the competency.
Your Honor, number 24, I know that he has a serious felony charge where he would not be prejudiced by resetting that week. That would be our request. Reset that a week, please. 24.
Okay, reset that. What's the date?
9/7.
Okay, 24 is going to be reset to 9/7.
Thank you.
All right. And then what was the other one? What was the other case?
The case I was talking about, Your Honor, is position 9. I don't know if that's
Yes,
the
that's
case.
the only where, the
Oh,
only,
that's the one they're waiting on the conflict. Defender?
yes, Judge.
Yes, that's it. Position 9.
Judge, can we just reset that case to Tuesday? He has a felony hold with no bond.
Yeah,
So,
they're not going
and then
anywhere.
I can contact Ms. McLeod.
Okay.
She's not trying to rush to go through the case with her.
Okay. Set that one to 9/7. Is that right, Miss Grace?
Yes, ma'am, that would be fine.
Okay. And
Your
then
Honor,
does
can
that-
pretrial be excused?
I was gonna say, yes, that will clear us out. All right, thank you, pretrial.
Thank you. Have a wonderful day.
You too. All right, does that clear out and conclude the state all-purpose calendar?
Your Honor, are we still doing position number 9?
No, we reset it
We said it, what date?
to 9/7.
9/7?
Yeah.
All right. They reset you.
Is that it, Ms. Grace?
Speak of anything, man.
They reset
Like
you.
that's talking about damn, man.
Judge,
Is that everything? Is that everything, Mr. Jordan?
If they want to hold him at Fort North for a second.
I'm sorry.
Ms. McLeod is logging on.
Okay, good afternoon, Ms. McLeod. You're on mute.
Good afternoon, Your Honor.
Yeah. Are you, we had just reset position 9, Mario Dawson, to 9/7. I don't know which would you like to do?
Whatever the court wishes me to do, Your Honor.
Yes, Your Honor, I hadn't even hit send on that email yet to Ms. McLeod, so I'm not even sure she's aware that we need conflict counsel for position number 9 on the SAP calendar.
I haven't reset it as of yet, Judge, so whatever you guys would like to do.
All right, PD Adams, do you need a second to talk to Ms. McLeod, or what would you all like to do quickly?
Well, it's just, we don't even need to have a long conversation position. We are conflicted in position number 9 on the SAP calendar. I can forward you the information, the calendar, Ms. McLeod, if you like.
That would be fine. Whatever you want to do, I'd be happy to take a look at it now.
Okay,
I'm not sure if he's still at 4 North or if they took him back.
oh, if they've taken him back, we may be, because we already told them we were resetting.
That would be fine, Your Honor. If the information is sent to me, I will look at it and I can be available for the next calendar.
Yeah, I think 4 North is signed off. I think Mr. Jordan is correct. They've probably taken him back.
I still see them on, but they're probably gone.
Yeah, right, so they were logged on, they just never turned the camera back on.
4 North? Is there any way to find out, Mr. Jordan, or is he still out or in, or?
I think they logged off completely now.
I was about to say the same thing, they just logged off.
The numbers weren't adding up to the location in the time matter of actually the product receipt. We had 9 drinks in the account, and we don't have 9 customers coming in. That's 5. No, like that.
Well, Lisa's scam.
She's done.
Oh, it's completely down.
All right, so when you see the person get up, just go away from me. Tell them. Go. All right.
But I feel some worry.
Back row. Same thing.
But then I was like, 3 officers come on, same location.
Move.
All
right. Heard this, man?
Wondering why I was expecting me to put my hands on my legs. And then it's like I put my hands on my back.
What are we doing?
Your Honor, that concludes everything that's on the SAP calendar. And so I believe you guys still have some competence.
Yeah, we're ready to start that. I'm gonna
Yes.
because I think he's been taken back with 4 North, my personal opinion. So I guess if you all work that out with Ms. McLeod, fine, but if not, I'm ready to move forward and start this competency calendar. I have to see it 2 o'clock, so I need to get through this.
Yeah, I sent the information to Ms. McLeod, so I guess we can just keep it reset for 9/7.
There was a young lady that walked up on me with the same child, and she said that's her daughter. And me being custody with handcuffs on me, there was no way that someone would be able to swing on me with her arm on me.
Who's all going into the breakout room for the competency hearing?
All right, let's do that, please.
Which was fine, because she felt like I was putting my hands on her child.
Judge Mincy, I was just saying, I think with regards to position number 9, we can just keep him reset for 9/7.
So.
That's fine.
May myself and Mr. McLean be excused, Your Honor?
Yes, you may. Thank you.
Please make sure all the paperwork is sent over.
Timely
manner, please. Thank you.
Quick as possible to Miss Grace.
Yes, Ms. Grace, there'll be a slight delay because the copy machine in the jail is down, but we'll get it to you today.
All right, we're going into the breakout.
Who else going into the breakout room?
I think everybody who's left. Mr. Walker, Ferguson, Elon.
Mr. Howard,
Burgess.
and I see a Miss Carletha Wright. She is the victim on one of our cases. I don't know if Derek wants to handle that case first, but if she can be included.
Yeah, she's the mother
Yes, please, so.
of Mr. Wright. We can do that one first, I guess, while she's here. Good afternoon, Mr. Howard. You're muted.
No,
There
Judge.
you Hi, we have a victim or mother on the Zoom with us.
All right. Are we in breakout already?
I don't think so.
I haven't hit the button yet. Was that Miss Wright? For the
Yes.
breakout?
I can leave here too, correct? Who's Tommy Johnson?
I'm not sure, Judge. He was on here earlier, but he never.
Oh,
appeared on
we
here.
don't know who that is.
So
Okay.
that's everybody.
All right, I'll sign out. Thank you, Michael.
Good, Judge. See
Your
you guys
Honor,
too.
Your Honor,
Oh, yes,
are we still doing the competency?
we're done.
Oh, so what happened with Mr. Wright? Nobody came on and said anything about Mr. Wright. I had him sitting in this chair.
Oh, I'm sorry.
Eric
Mr.
Howard told me to bring him down, and he's been here the whole time morning.
Oh, I guess he forgot. We did a $1,000 bond through the jail,
Okay.
and his cousin and mother are gonna be listed to pick him up. So they need to be called. We added their names and numbers for Marcavius Wright and his mom Carlethia Wright. One of them or both of them will pick him up. He's only to be released to them.
Okay.
Just tell him that his mom is coming to pick, his mom and his cousin is gonna come pick him up tomorrow.
He hears you. He hears you.
Yes, his mom,
Thank
I'm
you,
conscious of the
Pastor.
social worker, his mom, your mom, Carlethia, or your cousin Marquavius will be at the jail to pick you up. They're just waiting for the jail to call them when you're ready to be released.
Okay,
Yeah.
okay. And I'm sorry, Deputy.
Not a problem.
All right, thank you. Take care.
Right, you too. See you at 2 o'clock.
Huh?
See you at
I
2.
know, see you, yeah. I'm gonna run and grab a potato chip and I'll be back.
Norris, do you think they need social workers assistance today?
Oh, man. You really want me to say that?
No,
Oh.
not alive, not live. Never mind. I'll call you.
Read between
Yeah.
the lines. Read between the lines.
Okay, no problem.
All right.
All right, bye-bye.